Deputy Chairman, sir, for giving me this opportunity. Yes. The National Commission for the Minority Educational Institution has been constituted in the year 2005 by the previous UPA government. Until date, it has been functioning very successfully. Though the decisions of the NCMEI shortly for this commission are recommendatory in nature to both the central government and the state government, it has been functioning very effectively. I would like to recall here very happily that I had the privilege of being the member of this commission representing the Christian minority. Though the membership was for a very short period, I had to resign it to become a member of this august house. I could realize some practical difficulties of the commission in implementing some of the provisions of the NCMEI Act. Hence, this amendment bill has been proposed after taking into careful consideration of so many Supreme Court's rulings and also some other relevant points. First, it is proposed that the definition of the minority educational institution can be newly defined by omitting the words other than a university and by substituting the words established and administer for the words established or maintained. This proposed amendment is clear in nature and clarificatory also, hence I support this amendment. Next comes the amendment for increasing the number from 2 to 3. Considering the how do they fare well in the commission, I welcome this amendment also, sir. I heartily congratulate the pro-minority UPA government for setting up this commission for the redressal of the minority educational institutions all over India separately. Under the able chairmanship of Justice M.S.A. Siddiqui, the commission is performing very well. Whenever a minority education institution in any state, of course except the J&K, is aggrieved of any rights, they can approach the NCMEI like a civil court. This is a cost-free mechanism for giving relief to the minority educational institutions. That is, there is no need to appoint any advocate or anything of that sort. The aggrieved institutions can represent themselves. The Commission has disposed of all the 373 cases that came in 2005. And in 2006, out of 2074, 2069 cases are cleared. In 2007, all the 1096 cases they have cleared. In 2008, out of 1648, 1617 cases are cleared. In 2009, out of 1833, 1471 are cleared. In 2010, that's the current year, out of 1231, 403 cases are cleared. In view of the best performance given by the Commission, sir, redressing the minority educational institution, the increase in the number is highly justifiable. But sir, Article 30 of the Constitution applies to both religious and also linguistic minorities. Hence, the linguistic minorities should also be brought under the ambit of this Commission. The Joint Parliamentary Committee has also recommended this point. A few more numbers can also be increased in the number of the members, considering that linguistic minorities should also be brought under this ambit. The further amendment, sir, is for subsection 1 of section 10. A bare reading of this section, it gives the meaning that NOC is required for starting any minority educational institution, but the fact is not so. But the Supreme Court has clearly held in the case of state of Maharashtra versus Sant Jnaneshwar Shikshan Sastha Mahavidyalaya and others. It has been held by the Supreme Court in this case that so far as coordination and determination of standards for the education and research in scientific and technical institutions are concerned, the subject is exclusively covered by entry 66 of list 1 of schedule 7 to the Constitution, and the state has no power to encroach upon the legislative power of the Parliament. In such cases, NOC is not required from the state government. Therefore, subject to such law, any may be made by the appropriate government is added. This amendment is also a welcome amendment, sir. The next amendment is for subsection 4 of section 12B, that the words "and in consultation with the state government" shall be omitted. A bare reading of this amendment sounds as if this amendment is against depriving the rights of the state government. I am from Tamil Nadu, sir, where our Chief Minister and the leader of our party has always fought for the rights of the state government and for the minorities also. A clear reading of this amendment is required. If an appeal provided under section 12B is to be decided with the consent or concurrence of the state government, then that procedure will be offending the principles of natural justice, as the minister has rightly pointed out here. It virtually takes away the substantive right of appeal created in favor of an aggrieved party, as the result of the appeal will depend not on the merits of the case, but on the consent of the respondent, and that would result in gross injustice to the appellant. It is hardly likely that was the intention of the legislature, as such an interpretation would lead to absurdity or injustice to one of the parties in the proceedings. The aforesaid expression also leads to an interference that what the parliament has given with one hand, it is taking away the rights with the other hand. Since the expression and in consultation with the state government completely destroys the right of appeal created in favor of the aggrieved party, it is appropriate to delete this expression. Hence, this is a suitable amendment, sir. Before concluding, sir, I would like to say, bring to this august house, as a previous member, I have noticed that the orders are all passed well in time by the commission, but 90% of the orders are being executed by the state governments, but there are certain state governments which do not follow. I propose that the further amendment should be brought to ensure that these orders are passed by the commission have to be enacted also. In other words, I would say that constitutional status has to be conferred upon this commission, considering the well functioning of this commission, sir. With this, I would like to welcome all the amendments. Thank you, sir.
Shri Kishore Kumar Mohanty.
उपाध्यक्ष महोदय, आज द नेशनल कमीशन फॉर माइनॉरिटी एजुकेशनल इंस्टीट्यूशन अमेंडमेंट बिल